I really hate that I'm here. And not because of you all, but I hate that this is even a subject that we need to talk about. But I'm very, very passionate about it, and I have been going around and talking to groups for the past 4 years or so. So I have a few questions that I want to ask you before I dive in to the conversation around this. First of all, are there any attorneys in the room? Okay, good, because I have some things to say about them. So who in here is a business owner? Okay. This absolutely applies to business owners. Who here is a manager or leader at an organization? Okay, several of you, great. You have a responsibility to let the business owners know about this. Who here knows a business owner that they care about? Yeah, okay. You have a responsibility to let your business owner friends know about this because everybody is susceptible to it. Is there anyone in the room that knows of an active lawsuit going on around ADA compliance for websites or SEPA? No one. Okay. There are a lot of them going on. And here's the thing. Nobody knows or believes that they are going to get sued or that they are subject to lawsuits. Most business owners and business leaders have no idea that their websites have to comply with the Americans with Disabilities Act because we think ramps, handrails, things like this. But the Department of Justice ruled that websites are places of public accommodations, and that is what makes the Americans with Disabilities Act a thing. It's places of a public accommodation that we have to allow for people with disabilities to engage and interact with our spaces. Since websites now are so prevalent, they have been ruled by the DOJ as places of public accommodation, and this is why they now fall under the Americans with Disabilities Act. You should know that nowhere in the ADA law does it say the word website, which is amazing. But you'll see that businesses have doled out hundreds and hundreds of thousands of dollars in penalties as a result of their websites not being ADA compliant. So the numbers are actually pretty crazy. These are just 2025 numbers. So 3,948 lawsuits were filed against business owners across the United States for non-ADA compliance for their websites. That sounds like a pretty small number in the scheme of things. Sounds like it's not a problem. But the fact is, a conservative, like super conservative estimate is you multiply that number by 50 and that's the reality. So it's almost 200,000 businesses. And the reason why is because most businesses get demand letters first. Demand letters are private, so there's no public record of those. And then these business owners settle for tens and hundreds of thousands of dollars in penalties. 85 in Missouri times 50, so a little over 4,200 just last year. And then we'll talk about this 800 number that I have on the slide. This is the new wave. So the ADA lawsuit wave has been going on for about 3 years, 4 years maybe. SEPA is new. And this is going to be fun. They actually can get more money out of you for SEPA. So we'll dive into that. The numbers though, so none of you are business owners in the room, but you are leaders and you know small business owners. So you need to understand that the numbers are actually very, very significant. When someone gets a demand letter, a small business owner, medium business owner, large business owner, they're going after everybody. They're looking at $5,000 to $20,000 first. That's the first number that we're paying. And that is just the settlement that they're demanding out of the gate. Business owners then think, oh, well, is this real? Is this a scam? I don't know. I better talk to an attorney. Then they're looking at legal fees. So you pile on the numbers. And then after that, the attorney says, actually, yeah, it's real. Yeah, you have to fix it. And you have to pay me for my time. You probably don't want to go to court because you're not going to win. So then they reach out to companies like mine and they ask us to go fix it for them. So then you've got that fee on top of it. So in the scheme of things, depending on how egregious and how large the website is, business owners are looking at anywhere from $18,000 to $70,000 on average in penalties to make this go away. And just because it goes away the first time doesn't mean they can't get sued again. So they go fix it, and then what happens is they make changes to their website, throws it out of compliance, and then they can get sued again. And I've seen numbers out there that as much as 40% of these ADA compliance lawsuits are repeat attempts at, and I'm just going to use the word extortion because I believe that's what it is. That's why I asked if there are any attorneys in the room. So, I like to be clear out of the gate that I do believe accessibility matters. I have people in my family and I have friends who need accessibility things on websites in order to navigate and function and live. It's important. It's very important. But what I hate is it's not those people and their family members suing businesses. It is a small group of predatory law firms around the country that are doing this. The number of real claims from people are very, very tiny. These large numbers are, I can't remember the numbers, but it's like 20 law firms across the country where this is their sole business model.
Wow.
It's crazy. And the plaintiffs in the case, or the claimants in the case, I don't know which word is technically correct, but the person that says, I'm suing this business for this, they're hired by the law firms. So they are legitimately people with a disability of some kind, but they're hired by the law firms. The worst part about it is the Americans with Disabilities Act does not allow for damages to be awarded to claimants. It only allows for attorney's fees. So guess what? The attorneys are paying the claimants $500 to $1,000, and then the attorneys are getting the tens and hundreds of thousands of dollars. That's what's really going on out there, and it really, really makes me mad. So I'm Sandy Waggett. I own MSW Interactive Designs, which is a digital marketing agency. It's down at Lake of the Ozarks, but we serve clients nationwide. It's a 26-year-old company, so I've seen a lot of things. The reason I go around and talk about this, I'm passionate about it. I've had a lot of clients sued. I've had a lot of small businesses come to me that have been sued asking for our help to clean it up. And so we do that. I did testify in front of the House committee that put forth the bill that was recently turned into law in Missouri about this subject. It's called Missouri SB 907. So it was passed. It goes into effect August 28th of 2026. So there's some protection for Missouri business owners. And what I testified in front of the House committee is that we need a period longer than 30 days because what they had proposed was you have to give a business 30 days notice before you can sue them. So essentially it's a notifying cure. I'm someone with a disability, I can't navigate your website. I'm gonna sue you because of the Americans with Disabilities Act allows me to, and you have to fix it, and you have to pay my attorney, who I had to hire to do this for you. 30 days is not long enough for a business because if you think about it, you get the letter says you have to pay $17,000 or $75,000 for these things, and I'll talk to you about what those things are. And the business owner is like, well, what is this? This is a scam. And then they set it aside. And then they get a second letter. It's like, oh, well, maybe it's not a scam. I better talk to an attorney. So you can see how the days quickly tick away. 30 days is not long enough. So I advocated for 90 days, and that's ultimately what was passed. Because by the time they figure it out, meet with their attorney, the attorney says, yes, you have to fix it. Yes, you have to pay. I'll try to get them down to a lower number for you. Then they call a company like mine to fix it. We need that 90-day window. But here's the thing. It sounds really good. It is good right now. But the problem is that federal law trumps state law. You've probably heard that before. So this is a brand new bill. And like I said, it goes into effect August 28th. But as soon as it goes into effect, and then someone uses it to defend themselves, guess what? It's probably going to be challenged by an attorney saying, hey, this law doesn't matter because federal law says this. So you just need to know the Missouri law. It sounds cool and it may serve as a deterrent to these predatory firms, because remember, they're not really real claims that are happening out there. Predatory firms want easy, fast. They don't want to spend a lot of time and energy on it. So I believe it will serve as a deterrent more than anything. But you still are required to have an ADA compliant website. The business owner is susceptible. And what was your name? Elena. So Elena was telling me she works for a nonprofit, a very small nonprofit. And she's like, I hope you're telling me that we're exempt. You're not exempt. So I'm sorry about that. The only people who are exempt right now are religious organizations. Everyone else is subject to this. And the sad part is, and I see it over and over and over again because I work with small businesses and small organizations, is that that's actually who they're targeting, because that group really can't afford to hire attorneys to defend themselves, so they tend to settle. There's a little mom and pop business, is a very good friend of mine, sued for $75,000, and it ultimately put them out of business. They tried to settle for less. I think they came down to 50, something like that, but that was still too much. Business owners don't have that kind of cash laying around. So it's just heartbreaking to me. So in the end of this presentation, I'm gonna have a QR code that you can scan and get this. So don't worry, you don't have to take a ton of notes about this. But when you get the presentation, please pass this on to business owners that you know. It's so important. This is the stuff that you need to have, and I'm going to show you a plan on how to be proactive and try to prevent getting sued or getting a demand letter. So a website must be perceivable, operable, understandable, and robust. So perceivable is that the user has to be able to see or hear the content. Have you heard of screen readers? Okay, so we think of people that are blind or deaf. It needs to be perceivable. It needs to be operable, meaning they need to be able to navigate the site without a mouse. So we think of blind and deaf, but we don't think about people who have loss of limbs or no dexterity, so they can't use a mouse at all. So that has to be navigable without a mouse. And it has to be understandable, meaning the content has to be clear and predictable, because screen readers, have any of you ever been on a website through a screen reader? Okay, it really sucks. It's so weird. And it's so hard. And when it's not accessible, the screen readers, when they get stuck, it's a very bizarre experience. I believe they need to be accessible and business owners should fix it. I totally believe that. But most business owners don't know that it's a thing. They just have no idea. It has to be understandable by screen readers, not by us looking at it. And then it has to be robust, meaning it has to work with assistive technologies. So I'm not going to read this screen to you, but this is an important screen to share when you get the slides. Send this to your business owner friends, send it to your boss. And if you work for a big hotel chain, tell me, are they like franchise owned, or are they just 100% corporate, or what does that look like in your space? Franchise owned.
But
so
the corporate still handles our website.
Okay, all right. Well, a company like Hilton hopefully knows and is taking action around this. But if you have business owner friends, I guarantee you they don't know. So you would be doing them a massive service by sending this to them. The bottom line is you have to do some things that are pretty fundamental besides getting your website accessible. And I'm going to go through, I think it's 9 or 10 steps that I have in here, but essentially documentation is really, really critical. You need to have an accessibility statement on a website. We've gotten to the point where we're putting them at the very top of the website. You need to do periodic audits on the website. You have to have a plan for ongoing maintenance, and you have to have a documented response plan. The reason you have to do all of these things is because when the company gets sued, you have to have documentation that you made a good faith effort and an ongoing effort to make the website accessible. So I'm just going to go through a few steps. I'm not going to read these screens to you, so I'll go pretty quickly, but if at any point you have a question, just stop me. You need to have a clear accessibility standard. The DOJ has ruled that the WCAG 2.1 AA standard is the one that they are measuring against. So make it that one. Don't make it something else. Just make it that one, because that is the standard. And in the documentation, I've got this line in quotes up here on the slide. You need to actually say, our website is designed to conform to WCAG 2.1 AA as much as possible. Second one is to conduct an accessibility audit. So when all these predatory lawsuits first started happening, I, like many other companies like mine, started looking for solutions, because to design a website from scratch that is fully accessible to the standards written in this DOJ thing is very expensive. It takes hours, a long time, and it's highly technical. Most business owners could not afford to do this. Most small business owners might pay about $5,000 for a website. We're talking 50 grand for something from scratch that is fully compliant. So we were looking for solutions. And so there came out a bunch of tools. We call them overlays, accessibility overlays. There's some free ones out there. The one that I bought into is a company called Accessibility. And what it does is it puts a little widget on your website so that when someone comes to the website that has a disability, the screen reader can see it, and it activates the widget, and then the widget has options. So it can help them navigate it. It can turn off things moving on the screen. If you have a seizure profile, it can zoom in large text and focus on the screen if you have ADD. So what I love about these widgets is that they accommodate things much more than the simple screen readers do. It covers all kinds of disabilities, so they're highly effective.
What's it called?
Accessibility. Like accessible, only Accessibility. The problem now, though, is that then these law firms sued people. The courts ruled that, nope, this does not make the website compliant. Yes, it's a Band-Aid. Yes, it makes it functional. Well, isn't that the goal, is to make it functional? Apparently not, because they ruled that, nope, doesn't work. You have to modify the code. Okay, so that kind of stinks. I still use Accessibility on client websites because it actually does make the website super accessible beyond just screen readers and all of the basic things. So I love it, but we also go in and we modify the code. So there's two tools that I recommend. WAVE is one of them. So if you go to webaim.org, and that'll be at the end, or Lighthouse, which is in the Chrome extension, you can run an accessibility check on any website. So I would encourage you to any website that you're involved with, that CBB website or even your Hilton website or your organization website, just put it into the WAVE tool and see what comes up. In WAVE, we personally, this is not documented anywhere, but my agency, we go for 0 errors. None, no errors. Most websites, when you run them, will come back with 10, 50, 100 errors, 0 errors. That's the one big thing. If there's an error, because when these attorneys are scanning websites with these bots looking for people to sue, they use bots to start. So the bots can process lots and lots of websites really fast and then flag them. And once they're flagged, then a human goes and looks at them. So if you can get your WAVE score with 0 errors, you're less likely to be flagged. And then the second one is Lighthouse, and we strive for 97% accessible out of 100. So 97 is our threshold. Again, not documented anywhere, but this is what we try to do with our agency to protect our clients. The next thing is fix the highest risk issues first. So these bots, the first thing they do is they go look for missing alt tags. Does anyone in the room know what an alt tag is? Okay, what is it?
It's like, oh, sorry.
Go ahead, yeah.
We were both right here.
Yeah, absolutely.
It's like text that's coded into an image that can be picked up by a screen reader.
Exactly. So it's text that is essentially in the code behind the scenes. The user can't see it. In some cases, you can hover over the image and see it, but it's meant for screen readers to describe the image. So alt text, A lot of people in their alt text will just write, well, first of all, most people put nothing. Don't do that. Always make sure you have alt text on your images. And the alt text needs to actually accurately describe the image. So you have to put a little more effort into alt tags to be compliant according to the standards here. Fully describe the image. So any image that serves a purpose in the message or the context of the website has to have alt tags. There are some images that are for decoration only. Those are the only exceptions to the rule. However, I advise everybody to put alt text on every image because, again, these are bots detecting it. And so if they're scanning your homepage and you have 4 missing alt tags and all they are is little decorative icons on the page, the bot can't tell what that is. It's just a flag. So we're trying not to get flagged is what we're trying to do in this conversation.
Just like put the alt text as decorative bar.
Yes, you can. Yeah, I'm just saying don't leave it empty.
Yeah.
Even though technically, if you were to get sued and try to defend yourself, you would be fine leaving them empty if it was decorative only. Yeah.
What was the question? I didn't catch that question.
Oh, she said, couldn't you just put decorative bar in the, and you can, because we do have decorative bars on our websites, right? Because we want to separate visually. The other thing that is flagged often is poor color contrast. So think about your beautiful websites with soft color palettes, gray text, you know, peach and all the modern colors. They look amazing. Nope, bad idea. So if it's not high contrast, it's going to get flagged. And by the way, red on black gets flagged as well. So the big bold websites that have red text on them, bad idea. The best contrast is white on black. Anything after that, there's a threshold. So WebAIM will identify those, the tool that I told you to use, the scan.
You said white on black, like white text on black?
Black and white.
Okay.
Yeah, I'm sorry. Yeah, black and white is what I mean.
Okay.
That's the highest contrast apart from each other. And then the other big one that we see is unlabeled inputs. So forms, in other words. And this can be very misleading for people because they have the form on the website and we say, no, it has to be labeled. Well, it is labeled. It says first name, last name, telephone number, address. I'm not talking about the labels that you see on the screen. I'm talking about the labels behind in the fields on the code. Those are usually not labeled. So your developer, whoever is building the website, needs to make sure that the fields on the back end of the website are also labeled for screen readers and also navigation engines that don't use a mouse, essentially. And then those lead to keyboard traps and all the things that we have, the rest of the stuff on this slide. As you are doing a scan, identifying things and then fixing them, you need to document. Document you did the scan, the date you did it, what you fixed, when it was fixed, and who fixed it. And then put that in a folder. So save all of that because that log then becomes something that can defend you or help you negotiate that you are actually actively trying to be accessible with your website. So I talked about this a little bit earlier. You want to make sure you have a very strong accessibility statement. These are the things that I recommend go in your accessibility statement. So your commitment, the standard, the date, the contact method for reporting barriers. So if someone gets stuck, who do they need to call or email or talk to? The response time frame. So if I email you or call you, how quickly are you going to get back to me? And then put it at the top of your website. So a lot of people now will take and they'll go, oh, okay, I need an accessibility statement. They'll put it down, and I call it the junk drawer at the bottom of the website where all the links are and copyright and all of that. Don't do that, because if a screen reader comes to your website at the top and gets stuck and never gets to the bottom, what good is that accessibility statement? So that'll cause you problems. It'll get flagged with the bots, and for people who actually need the website to be accessible, they're never going to get to it for the help that they need. So for websites that we build now, it's at the very top. It is the first thing that a screen reader or a navigation engine is going to see, accessibility statement. And so here's how to contact us if you get stuck. Okay, then make sure, because you could be tested, if you say contact this person, they're going to get back to you within X amount of days, make sure that that actually happens, because you could be tested if you're being targeted. And if you don't do it, guess what? Then you're sued. Next thing is to create an internal SOP, standard operating procedure. So you want to make sure that whoever's managing the website has this SOP. They're accountable to doing all of these things. I'm not going to read the slide. These are all the things that make the website accessible. So pass this on. Pass this on to your business owner friends. Pass this on to your business owners.
So an organization that is constantly creating a new activity and here's a new page with a new activity that we're doing,
Yes,
that each one of those got to do all this stuff.
you do. You do. And that's what this next one is. Implement an ongoing monitoring program, because anytime you make an update to a website, you are at risk of making it non-compliant again. So if you're putting a new image on a website for an event or something that's coming up, if those alt tags are missing, if the keyboard navigation through the registration form is missing, it's suddenly not compliant. So you need to have an ongoing monitoring thing. And as a web design company and agency, we do updates for clients. And we actually now, anytime we make an update to a website, we go rescan the website every single time.
So we had a presentation, we videotaped it, we posted it as, if you missed this presentation, you can go watch this video. We're gonna have to find a way for that video to be text readable for the non-hearing audience member who finds our website.
Really good point. On video, you should have captions on the video.
We should have captions.
Captions, yep. Yep.
Okay.
If you have captions on the video, you're good.
I have no clue how to put captions on the video.
Right. Well, you know, the really nice thing is, in the age of AI, now it's a little bit easier than it used to be. So people who don't have the technical expertise suddenly can use AI to help get instructions on how to do that. So that is kind of the beauty of it. The next one is to avoid over-reliance on overlays. So I described accessibility, and the courts have ruled essentially against accessibility, even though accessibility does make the website super accessible. So now it's a combination. You've got to still go do the stuff on the code, and if you really do truly want the website to be accessible to as many people as possible, the overlays are great. The overlays just don't protect you. So you just need to know that, because there's a lot of people with a false sense of security now that they've got these overlays on their website. And then reduce your target profile. So don't put unnecessary stuff on your website that you have to maintain ADA compliance against. So things that are easy to flag and these bots go after: online menus, ordering and checkout, booking, scheduling reservations, contact forms, quote forms, application forms, searchable catalogs, and product databases. All the things that people want on websites so that they can do stuff. And then the commonality is, this is how people are trying to give you money. So these are the things that you need to go check first, because these things are being tested. And third-party things. A lot of, especially small businesses, have third-party widgets on their websites that give it and extend functionality, which is great, but the third party, if it's not ADA compliant, who's responsible? You would think the third party, they are too, but so are you. You are not exempt. If you have a third party widget on your website and it is not accessible, you are responsible for that. That just happened to a client of mine, a big client that has several restaurant locations in the St. Louis area. They got a letter, and it was their third-party menu application, and they reached out to the company, and the company said, "Oh yeah, we know, we're working on it." That does not help my client at all, and he has no control over it. So guess what he did? He took it off. Does he still have to pay? Yes, unfortunately. So it sucks. Next one is to be proactive around insurance and legal protection. So I advise clients to go make sure they review their insurance policies. Check your insurance policy for policy exclusions or inclusions. Some companies have protection against this. Most of them don't. A lot of people think that they're covered, errors and omissions. Check your policy. And then make sure that you identify a defense attorney before you need them, because the window's short, and when this happens, you want to make sure that you're working with someone who is knowledgeable and has experience around these ADA compliance issues, because it's a very tricky field. So just make sure, be proactive, have it at hand, and then make sure that you've got a response protocol in place. So you get the letter, what's going to happen? Step by step by step, and just have it documented. Yes?
In mid-Missouri, do we actually have any defense attorneys who know anything about this?
So I don't know any personally in mid-Missouri, but there are a lot of them in St. Louis and Kansas City.
Because they've already been hit.
Yep. And then number 10 is maintain a compliance binder digital folder. So all of these things that I'm telling you to document, make sure that they're in a single folder, a place where you can just go and grab them really easily in the event that you get a letter. And that way you can say, we do have an ongoing accessibility program here. And then that gives you leverage in negotiation. It doesn't let you off the hook if something's not accessible and you get flagged, but it does give you leverage in negotiation. So I do have this roadmap that you're going to be able to download. I don't expect you to read it up here. And there's a QR code. I'm going to show you this QR code in a minute again. So you can scan it now or scan it in a minute. But these are the 3 things I'd like you to do. So a website that matters to you. So either your company or a friend of yours that is a business owner, go scan it and see how many errors are showing. And then in your case, there's no business owners in the room, but tell your business owner friends or the owner of the company that you work for to start the compliance record today. The fact that you are here for Hilton or Marriott or whatever company, this is an effort to be compliant. It should be documented because you're here getting educated. So this is a compliance step. So document it and put it in that folder, and then share this with an organization or a business owner. I see some of you writing down, I promise I'm going to come back. But wait, there's more. How many of you were in the session I did in Jefferson City a couple months ago in June? I knew I recognized your face. We did not talk about this there. It was happening, but we didn't really talk about it. So SEPA is the new wave of website legislation. So SEPA stands for California Invasion of Privacy Act. It is a 1967, yes, 1967. That was the year I was born, you guys. That applies to your website. Did they have websites in 1967? No. So do you think this was the intent of this law? No. But guess what? It applies. The courts in California have ruled that it applies. And I know what you're thinking, but Sandy, we're not in California. No, we're not. But it applies. And this is why people in California are thinking about moving to Columbia or Lake of the Ozarks or St. Louis or Kansas City or Oklahoma City. They go on a website and all of a sudden you have a cookie, a script, or something that is tracking their activity. How many websites do you think don't have Google Analytics? Most do. That counts. It's crazy. So Google Analytics, other cookies, Facebook ads, Google ads, all these things rely on tracking code on the backside of a website. Well, this wiretapping law in California says, nope, you have to get express permission from the user before that script fires on the back end of a website, or you're breaking the law. So the bad thing is the penalty is $5,000 per incident, or 3 times damages, whichever is greater. So think about this. Let's just say you have a basic website. Let's say it is, let's go 5 pages, and all you have on it is Google Analytics. So Google Analytics code is on 5 pages on your website. That's $25,000 right out of the gate if you get sued or a demand letter. That's some serious motivation for predatory lawsuits. But then if the person says, oh my gosh, I am so hurt by the fact that you tracked my activity on this website. I just can't get over it. You owe me $75,000 now. No, I think 150. 150 sounds good. I don't have to document or prove how badly I was hurt. I was just hurt. And they win. It's terrible. Again, most of these lawsuits that are happening are not real people claiming these things. They are firms that are going for money grabs and hiring people to be the claimant in the suit. Now, there's bigger incentive for these lawsuits than for ADA because they don't have to prove anything, and under SEPA, the claimant can get damages. So now people are more incentivized to play along with the predatory attorneys. So you just need to know about it. So how do you prevent it? Have you guys been on websites where there's those cookie banners at the bottom and you have to accept or say no, and they're really annoying because you go to a website and all you really want to do is get to the business, and then it's this weird pop-up? That's what it's there for. So it used to be people that just served, well, the EU started it, the European Union, and if you served people over there, you needed to have this, I think it's EULA is the formal name of it. You had to have this cookie banner on your website. Most small businesses don't, and so they just didn't bother. But then this California thing just kind of snuck in, even though it was from 1967. It was just a court that ruled, yeah, it applies. All of a sudden there's precedent, and now all of a sudden we have to be worried about it. And business owners don't know this. They don't see California news. But yet, business owners in Missouri, down at Lake of the Ozarks, where I am, are getting demand letters for breaking the SEPA law. And they have no defense. So you need to know about the SEPA law. Anyway, yeah. So this is just more stuff to add to your compliance folder. So all of the things on the back end of your website that are scripts that track things. So Google Analytics, most websites have it. Any kind of pixel, Facebook ads. We use a technology called Smart Visitor ID to identify people that come to a website, don't fill out a form. That counts. Google ads, any kind of tracking whatsoever. You need to have an inventory of it. And then you need to test the behavior of the tracking script with your cookie banner to make sure that they can either choose one. Let's say you have 5 scripts. They can choose 1, 2, and leave the other ones out, or it's all or nothing, just a yes or no. But you need to make sure if they say no, that those scripts aren't firing. That's a programming thing, which most people on the DIY websites, do-it-yourself websites, they don't know how to do that. But it's a real thing, and people are paying a lot of money for this right now. I understand, I do not know the name of it, but I understand that there is pending legislation in the state of California to make this not applicable under this 1967 law. I hope that it passes, but I don't know. So in the meantime, know that it exists. Once you're aware, you can't be unaware, and let everyone know that you know who has a website and owns a business that these are real things and real people are getting sued, they're getting demand letters, and they're getting hurt. And a lot of businesses are going out of business when they get because they just can't afford to do it. So 4 things instead of 3 that you need to do. Again, I'm sorry. I hate doing this presentation, but I'm very passionate about it because I've been doing this long enough and I've seen a lot of business owners just in tears over this. And it makes me really, really angry. So that's why I come do it. So I'm happy to answer any questions. That's all I've got, and I appreciate your time. Yes?
I know you're referring to website in this presentation, but
Yes.
that also applies to a Facebook page. anything that falls under your, representing your business?
So
Correct or
any
no?
widget on your website,
Widget on your
yeah,
website.
so a Facebook page,
You lead to it.
so Facebook owns your Facebook page.
Yeah.
You just use it.
Okay.
So Facebook is responsible for that. Now, if you take the Facebook widget and put it on your website,
Okay.
now you become responsible.
Okay, and is that also true, what we were told, I work for the city?
Yeah.
That even if you have a link to a PDF or to a New York Times or to anything else, that link has to go to a website.
So that's
That
a little
is-
bit different. So the question was links.
Yeah,
Do
okay.
links count? Links count, but let me be really clear about this. The link itself has to be accessible, so there needs to be a description in the link about where it goes.
Yeah.
So you gave a couple of different, very different examples.
Okay.
A PDF
Yeah.
that resides on your website,
Right.
you are absolutely responsible for the accessibility of that PDF.
Right.
A PDF that exists on someone else's website, you might be responsible for that because you are making it part of your content and sending them to it, but you could fight that.
Okay.
A third-party website that's just a link that you're referring out to, you're not responsible for their website, but if you embed content, a widget, onto your website from a functional standpoint, you're absolutely responsible for that.
My, that's crazy.
Yeah. Now, like for example, I'm going to say an equivalent example because if you're going out to New York Times just for looking at articles, that's very different than my restaurant that's in St. Louis that linked out to a menu platform, which is 100% third party, but it's tied to their stuff and it has to do with transacting and doing business with them in a very fundamental way. If someone wants to order food, they have to be able to navigate that website. And so this restaurant was responsible for that. So that's going to be a case-by-case basis, but still, yeah.
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 And one more question
Yeah.
related to that. So your widget that links to your Facebook page that you've had for 15 years,
Yeah.
and you go back, do you have to go back 15 years and do alt text on all those images on Facebook, or is it?
You don't need to put alt tag on your Facebook images.
Yeah.
That is Facebook's responsibility.
Okay.
But if you have the widget on your website and it's a functional part of your website and it can't be navigated, then you are going to be responsible if they are not ADA compliant. You have no way of putting stuff on their code on the back end. You can't fix it. You could just take it off and not use it.
Okay, so one way that we think we've come around for that is on our Facebook post, we do image description. We're not needing to do that because Facebook automatically puts an alt text and we could.
I would put,
alter that
if they give you an opportunity to put an image description, I would put the image
We
description.
do it as far as our write-up of the.
Yeah.
Okay, anyway.
Anything that you have the opportunity to put in data-wise. So example, Facebook ads, when you go in and you run an ad, I don't know if you've ever done that, you have an opportunity to put all kinds of things in and also include captions and all these things. Just put it all in. Put it all in.
Yeah.
Yep, yes, it is crazy. Any other questions? Okay, thank you for your time. I appreciate you. My contact information is right here. Feel free to reach out with questions at any time.